were discussing about section 60, subsection 3, where they provided a proviso that will undermine the 2027 official elections. I have now found a more dangerous 3 provisions, and I put them out so that I think that Nigerians can read it, they can see it before any comment. First, let's go to section 63. Now, section 63, which I just discovered, they have now reintroduced something very terrible. You can see it there. That ballot paper that will be used for the 2027 election, that does not bear the official manifesto security features of INEC, should be accepted by presiding officer. You can read it there. That where the returning officer satisfied, the word satisfied that was contained in section 49 of the 2010 Act that took us 20 years until 2022 to repeat, to remove, because what is the objective condition to determine what satisfies a presiding officer? A presiding officer has now been given the discretion to now accept ballot paper, notwithstanding the absence of the official mark, and to count that ballot paper. What that means is that before this election, politicians who now have access to the the security features of INEC ballot, they are going to produce their ballot papers.
They are going to print
their own ballot paper that have to be accepted. This is dangerous, as put in the Electoral Act. Similarly, may I show section 138? No, 138. Let's go to section 138. Section 138 has been one of the rigging provisions that we have cried out to be removed. As a matter of fact, you remember that in 2019, in this current republic, under Buhari was the only time that there was no Electoral Act passed. Because when we made that recommendation that this thing should be removed, this section should be removed, you remember that it was rejected. And what the section says? Grant of filing petition. It says that an act or omission which may be contrary to the instruction or directive of the commission or of an officer appointed for the purpose of election, but which is not contrary to the provision of this act, shall not of itself be a ground for questioning the election. May I make a few observations here? You see, when you want to deceive people, you put it in words. Bring that section back again. What they basically said, they were just short of referring to INEC regulations and guidelines, because the instruction and directive of INEC are contained in INEC regulation and guidelines. They are saying that a presiding officer, an assistant presiding officer, a collation officer, a returning officer, they can abandon it. So they provided immunity there without repeating. Then let's go to the last section. It will interest Nigerians to know that section 137 now says that all those categories of individuals, I think the other time I provided you what we call a pyramid. All the categories that we have just mentioned, presiding officer, returning officers, it says that where the petition, that's anybody go to petition now, to go to file a petition, complains of the conduct of an electoral officer, a presiding officer, returning officer, it shall not be necessary to join such officer. That is those who have disobeyed to follow INEC instruction and guidelines, that it shall not be necessary to bring them to the commission. That was why, you remember in 2019, in 2023 and previous elections, you find that because INEC has been joined, you are saying that the people who rig election, presiding officer who actually were the maker of the document, you said because you have joined INEC as a respondent, it shall not be necessary to bring them to the tribunal. Meanwhile, the courts have always complained about what we call dumping of documents, that petitioners should come and call for oral evidence. To deal with that, under section 137, in the 2022 Act, a new law was put in there to the effect that if document, because you remember that in the 2023 election, there were results, about 18,000 in different parts of the different, where they had different numbers of result sheet. that were mutilated. You could not read them, but votes were attributed to them. But they were certified by our commission. They were taken to court. You remember that when a director of our commission who unfairly was brought to speak to a document he did not make, he was not able to read them. Yet the court will now propose under the 2022 Act that have now been removed to the effect that once there's a complaint about non-compliance to the due process, to the extent that the document is before the court, certified as INEC document, it shall not be necessary to call oral evidence because of the fact that most of the presiding officer will not be around. Dr. Abati, as we speak, this provision that I have outlined, particularly, it means that at the level of the balloting, it has been sabotaged to the extent that ballot papers, you can now going to have ballot box stuffing, people are going to produce their ballot paper. Remember, in 2019, in 2 states, one in the southeast, one in the south-south, some unscrupulous members of our commission gave the serial number, gave the security features of ballot papers to politicians. And when INEC, in the case of Imo State, went to the court to say that this document, result sheet, is not our document. But guess what? The court, tribunal, upheld a forged document. This is where the role of the judiciary comes in. And this is where I am worried. When Dr. Abayo said, I have been, see, my clarion call since 2010 when I came to the commission has always been on the basis of my experience as a young man who had my first school in Ondo State when Fagbengbe was killed because of the outcome of election. And that's why I've always called on my constituents to say that our legal profession is not just to make a living. We have a special role to play in the life of a society. And that is why if Hussaini and Dr. Abadi, you have a problem, you come to us as lawyers. When you have a problem between yourself and government, you come to us as a lawyer. And that the lawyer, the judiciary, must be the last line of defense of democracy and the rule of law. But that has not happened historically and unfortunately.
Mr. Igini, thank you so much. There's a lot of information to process, and let's see how we can break it down one by one. Let me begin with where you landed, which is that, you know, you're supposed to be lawyers. What we're saying that we run to lawyers who take us to court, and that is supposed to be our line of defense for all conflict resolution. The Nigerian Bar Association, the president of the Nigerian Bar Association, had also indicted lawyers in a recent statement where he was saying that, well, as much as there's questions around the courts, that the lawyers are also behaving like political agents. How do we position that in this framework? Then secondly, you know, the sections you've spoken about, 63, 137, 138, but I think specifically 63 and 137 focus a lot on the role of these presiding officers, returning officers, ad hoc staff, in essence. How do we navigate around this? Because we've seen that the problems that are coming from ad hoc staff seem to be multiplying with each election cycle that we see. If it's not the poor management of ballot papers, there's more and more integrity being removed from the role that they play. However, we're still piling up responsibilities on them. How do we navigate that, given that this is the framework that we have going to 2027 and the elections will hold? What's the protective mechanism?
Yes. First, the EMB, I want to quickly advise INEC to quickly go back to the National Assembly to call for amendments for the repeal of this section 63 as quickly as possible. You see, a stone seeing coming should not blind the eye. Because this is the foundation. Yeah. The ballot is the foundation. You are saying that a ballot paper that does not have the serial number of the official mark of INEC should be accepted. You now give a discretion. Look at discretion given to a presiding officer. Meanwhile, this election, those who actually conduct election on election day for implementation are not the core regular staff of INEC.
Ad hoc staff, yeah.
They are ad hoc staff who have not been given the orientation or the fact that the mission of INEC, when we came in to restructure, was to be an effective, independent National Electoral Commission committed to the conduct of free, fair, and credible election for the sustenance of democracy in our country. And added to that, it is about core values. Now, Vimbai, to tell you, because I have conducted election, I have the privilege of being appointed by two presidents of the Federal Republic of different political parties. And I've traversed the entire country conducting elections. Do you know that there's another information that I put out there? Somebody that was arrested in my office. Presiding officer, these provisions, particularly that section 137, that you will not be. When I have trained, this was a young man. Look at all the cards that he was arrested with. And he was brought to my office. In the course of interrogation, he also, because these cards were the one that will be used when you say section 149, the one that had been repeated that took 20 years. He has all these cards. He's going to find his way into the ad hoc recruitment process. So when he gets in there, it is the party that have recruited him. They will give him these cards. Because the old section says that if the presiding officer is satisfied that the person before him is the rightful person, he shall tick the register of voters. So he has already cards to do that. Similarly, with respect to presiding officers, do you know that when I had trained people on a Wednesday for the 2019 election, for Saturday election, politicians went to share money for presiding officer. Dollars. If I were looking for the picture of that to also put on the table. Dollars. Some of them came to me. What did they tell me? They said, when I said, I train you people, and I said, some of you will be arrested if you don't observe the highest principle of ethical standard. I was told that they pointed out to them this section, that nothing will happen to them. They will not be invited to tribunal. So this provision we are seeing here, immunity has been provided for them. You rig election, you will not be invited. They said, any instruction of INEC, you cannot obey it. Nothing will happen to you. This is what they are going to do to train them. Now, the reason why I'm now referring or now asking my constituency to stand tall is the fact that in the final analysis, these matters will be taken to the court. We expect what we call a purposive interpretation, because every provision of the law that we have made proposal to change was on account of a mischief that we have found over time. It is now the duty of the court to advance the remedy that we have proffered and suppress the mischief. That has not been happening at the level of the court. This is the problem that we have. And that had to be solved. And so you are going to 2027 election. You already have provision that will undermine the entire elections. Because INEC chairman, national commissioner, Rex, EO, they are not going to be involved. On that day, they are merely supervisors. From the level of supervising presiding officers, who are members of federal agencies, down to the returning officers. They are people taken from federal agencies. And before that election, they are going to infiltrate all the federal agencies, all the agencies are going to do. And so on that day, you find out that people who are seated at the polling unit, they are doing the wrong thing. And that is why the last point on this was that we now develop what we call the EMSC, the Election Monitoring Support Center, as well as the EOSC, Election Operation Support System. My conference room, we have tracking system. I will track you, and that equipment was given to the entire INEC offices. All the characters that we proceeded against, sent to jail, some of our staff who were dismissed, it was on the basis of the tracking system that I sit in my office, I track whatever happened from one local government to the other.
Okay. Real quickly. It looks as though this law, as we speak today, is designed in such a way that the integrity of INEC is already destroyed leading up to this election. And it's a law that has been made to favor the political class, certain people in the political class. And with a law that constantly gives the presiding officers the power of discretion, where they will not be held accountable, our country is slipping into an abyss. The first question I'd like to ask you is, can you stake your money on the 2027 election? Because you've talked about this. I'm not sure INEC will go back and will get some amendment by the National Assembly. You know how much time it cost us to get this out? This will probably be it. So now, can you stake your integrity on these elections? That's number one. Number two will be the case of the presiding officers. Correct me if I'm wrong, which they normally filter in even from influences with the political class. There is no proper vetting. There is no proper understanding. And even with easy money, they can be swayed. So when we put such powers in the hands of people that we cannot hold accountable, it's not a big indictment on the election process.
Rufai, if these provisions, this 2026 Electoral Act, the provisions that I have identified are not repeated immediately, I want to say that the integrity of the 2027 election will be in flames. I say this because of my practical experience for 10 years and not 10 days of what I witness. Good laws, good processes that are not manned by men and women of integrity will not take a country anywhere. But inadequate law, inadequate process and procedure, manned by people who are committed to the ideal of democracy, will take a country somewhere. Election period is the moment where the integrity of institutions of states, particularly those who are responsible for the management of election, because election is a period for the renewal of the journey of a society, for the renewal of policies. And so when you have, and you still have enough time to change this, and you fail to change it, it means that we have decided as a people to do the wrong thing. Because law is not only an instrument of distributive instrument, but it's also an expression of our collective values. If our values is to say that we should be rigging elections, then it's unfortunate, because what gives legitimacy to those who in authority to exercise power is legitimate authority conferred on them by way of authorization, which enable them to be accountable.
Okay, Mr. Igini. Now, what I take from all of this is that the Electoral Act is a work in progress, as it has been since 1999. Every time we try to review it, reform it, amend it, then after the next election cycle, another protest will come and say there are aspects that we still need to correct further. So it's an evolving document. However, you are not alone in questioning the Electoral Act 2026. You have identified sections 63, 137, 138. IPAC, the Inter-Party Advisory Council, has identified sections 63, 83, 87, and 84. Section 84. Now, just this week, Justice Alaba Jileye, who is the leading authority on electronic evidence, has written a piece on section 47 on full digitalization as provided for in the Electoral 2026. And he says with regard to beavers, which the Electoral talks about in section 47, that it is compulsory. It doesn't offer a hybrid situation that INEC can play around with. It's either you get the beavers in terms of recognition of candidates ready, you can't now say if BVAS fails, you will now use manual accreditation. And that it is important that judiciary understands what the purview of the law is under that very foundational provision. The article is in This Day Lawyer this week. I think he has also written a bigger book on the whole of the Electoral Act. So the question I want to ask you is, okay, one, do you think there's still enough time with all these bodies and scholars, including yourself, saying this Electoral Act is defective? Do we still have time to amend it, to review further, or we just run with it as it is and then worry about it after the 2027 cycle? And what will be the implication of that?
Dr. Abati, why do somebody board a plane that we know is going to crash?
You are convinced
it's
the
not
election
necessary.
is going to crash.
I am saying this because how long does it take to amend, identify isolated provisions? Section 63, that's the foundation of the election. The argument that it is what kind of work in progress? The 2022 Electoral Act is a retrogression. And that's why in my opening remarks, I made the point that what differentiates advanced democracy, a growing democracy, and a retrogressive democracy like ours is a question of rule of law. The law must be stable and be neutral. The sanctity of the law is what generates interest in electoral process and confidence. The sanctity of the law and procedure in terms of public perception of the institutions of states, that is what is required. Dr. Abati, you asked a question. What would my advice to Mr. President the last time I came here? And I said, Mr. President, having regard to the role you have played before, and that this piece of then was a bill, let them go thoroughly. I'm not too sure whether people have read this or whether it was the court of transition that became a problem. The last one here is this. When I talk about judiciary, it's a fact that the cases we are having in court today are completely unnecessary because Section 83, just like Decree number 13, Section 32 of 1983, that bar the courts from entertaining any matters. Dr. Abati, it was my colleague who have an unregistered body to went to truncate June 12th. How can the other court to maintain status quo become order to remove antebellum?
Although one man called it
antebellum. All right.
Bello.
Antebellum. Right. So how do we explain that the order to maintain status quo led to the removal of status quo?
Removal.
Okay.
Is that word not have meaning?
Yes. All right.
Maintain. Remove. What are we saying here?
INEC chairman,
very
professor of law.
Points.
Finally.
Professor of law.
Very profound.
Finally.
Yes.
I must say this here.
10 seconds,
Yes.
please.
Democracy is what we fought for. Democracy has no place, will not survive in the soil of absolutism. We must work hard to ensure that this democracy survives. And at the heart of that is my constituency. I am making appeal to them that the institution of democracy will have no hopeful future if there is no opposition. That is what guarantees democracy.
On that note,
That is my happy appeal, so that we can build a society where there will be opportunity for all and responsibility from all.
The law is what the lawmaker says it is. That's the big dilemma that we face.
And that's why we need constitutional judges.
all right, Mr. Michael Igini, so much food for thought. But as your appeal says, we hope it